where there is no surveyor. Chapter 4: International Conventions and their impact on cargo claims. In this chapter, we will delve into three major international conventions that govern the carriage of goods by sea: the Hague Rules, the Hague-Visby Rules, and the Hamburg Rules. We will highlight the specific rules and articles relevant to cargo claims, offering an understanding of how these conventions impact the claims process and the responsibilities of the involved parties. 1. The Hague Rules, International Convention for the Unification of Certain Rules of Law Relating to Bills of Lading, 1924. The Hague Rules set the foundation for modern maritime law, defining the rights and obligations of carriers and cargo owners. Key provisions related to cargo claims include: Article 3, Rule 2, carriers must properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. This rule establishes the carrier's duty of care towards the cargo. Article 4, Rule 2. This rule outlines a list of 17 defenses that carriers can use to limit their liability for cargo damage or loss. Examples include perils of the sea, acts of God, and insufficient packing. 2. The Hague-Visby Rules, Protocol to amend the International Convention for the Unification of Certain Rules of Law Relating to Bills of Lading, 1968. The Hague-Visby Rules updated and expanded the Hague Rules, providing additional protections for cargo owners and clarifying carrier responsibilities. Key provisions related to cargo claims include: Article 3, Rule 6. This rule sets a one-year time limit for cargo claims, starting from the date of cargo delivery or when the cargo should have been delivered. This is typically referred to as the ETA. Article 4, Rule 5. The carrier's liability for cargo loss or damage is limited to 666.67 SDR, special drawing rights, per package or 2 SDR per kilogram of gross weight, whichever is higher. This rule establishes a monetary limit on the carrier's liability. 3. The Hamburg Rules, United Nations Convention on the Carriage of Goods by Sea, 1978. The Hamburg Rules aim to create a more balanced legal framework between carriers and cargo owners, with a focus on developing nations. Key provisions related to cargo claims include: Article 5. This article expands the carrier's liability by limiting the number of defenses available to them. Unlike the Hague and Hague-Visby Rules, the Hamburg Rules do not provide an exhaustive list of exceptions, making it more difficult for carriers to avoid liability. Article 8. The carrier's liability for cargo loss, damage, or delay is limited to 835 SDR per package or 2.5 SDR per kilogram of gross weight, whichever is higher. This represents an increase in liability limits compared to the Hague-Visby Rules. Article 20. The Hamburg Rules extend the time period within which a claim can be brought against a carrier from the 1 year provided under Hague and Hague-Visby Rules to 2 years.